Hello, this evening I'd like to talk about international environmental law. This is for Laws 19038 and it's based on Bates Environmental Law in Australia, Chapter 4. I'm reading from the text in part and you're welcome to follow with me in that regard. So I'd start at point 4.2 where Bates says that the main difference between domestic law and international law is that participants in international law are countries rather than individuals or corporations. And I guess that's a fairly obvious point. So it is about the relationship between countries that we're talking about in terms of international environmental law. It's often referred to as public international law as opposed to private international law, which is where individuals and corporations deal with each other in terms of international legislation and rules. In dealing with international law, it is harder than domestic law to define and identify the law, and that point's made at the bottom of page 97. Engagement of countries particularly in developing countries, there needs to be some certain agreements made, and that is often the case. Now, international law usually comprises of treaties. That's what we usually think of, but that's not necessarily and certainly not the only source of the law. So if we take you to page 100, you'll see that Bates describes international law as generally being divided into hard or soft law, hard law relating to treaties or conventions, but there are some principles of international law accepted as law because the international community recognises these principles have evolved over a period of time. And in that regard, there's reference to the International Court of Justice located in The Hague, where it may be possible for the ICJ to declare principles as international law. Now, soft law comprises principles such as sustainable development that are gaining increasing recognition and acceptance, but could not yet be said to have attained hard law status. A good example of a hard law in the making is the precautionary principle. So over on page 101 at 4.9, you'll see that the following are the areas where courts are now recognising international law. So firstly, hard law, international conventions or treaties, international custom, and then the general principles of law recognised by civilised nations and judicial teachings and decisions. Now that's a big departure from domestic law in that while judicial decisions do form part of our law, judicial teachings by teachings by publicists does not form part of our law. Now, international law, of course, doesn't bind individuals, but there can be some reliance upon international law principles in domestic dispute resolution. And then at 4.10, Bates goes on to talk about international conventions and treaties, saying that in many ways they tend to be reactive, but some things, such as the precautionary principle, does creep into treaties, and increasingly so. In terms of mechanics, once a treaty has been reached, or an agreement has been reached, the convention is open for signature and ratification. Nations become bound by the terms of the convention, not by the signature, but rather by the act of ratification. And in Australia, it's the federal government of the day, not the parliament, that makes the decision to ratify a treaty. So it's an executive level, not a legislative level, where Australia actually becomes bound by the terms of a treaty. Over the page at 4.12, environmental treaties are likely to be framework treaties. A framework provides for the general principles, but leaves open the mechanics for later negotiations. It's almost, in a sense, an agreement to agree, and further agreement can be done by protocols. All right, so that's the first of the sources of law, international conventions and treaties. The second is international custom. And at 4.14, Bates describes it as essentially unwritten but generally accepted international practice on a particular manner. He talks about the concept of good neighbourliness, for example, which postulates that when a nation is acting within its rights, it should take into account the rights and interests of its neighbours, and that's generally regarded as a customary rule. Treaties often define and formally develop those customary rules. Now, the third principle is those principles of international law recognised by civilised nations that can become, that is treated as the third area of law, and then finally judicial decisions and teaching of publicists. Now at 4.20, Bates goes on to talk about enforcement and compliance. Very difficult, of course, to enforce international law. There's no world environment regulator to take countries to court and prosecute them. In a way, it's a bit like the old Wild West. We have groups of people meaning well, trying to create an established law, but it just takes time, and it requires the administrative framework to be built up around, and a general acceptance of compliance. So the problem is at the moment that we don't have that at an international level. It is possible to make claims for compensation, nevertheless, but generally speaking, these sorts of things require some soft options. Now at 4.22, Bates describes those soft options, starting firstly with negotiation, particularly soft option. It then might escalate, if I can use that term, to mediation. Mediation involves having the parties come together voluntarily and the mediator providing the assistance to the parties to allow them to come to their own resolution of the dispute. But the mediator has no power beyond a formal right to be there and take control of the process, but no power to make decisions. Conciliation is a sort of halfway house to judicial settlement, where the conciliator can suggest solutions to the parties. In QCAT, we have mediations, which are the formal mediations, and we have compulsory conferences, which are more akin to conciliation. Binding arbitration is a form of settlement, and there's reference there to the southern bluefin tuna case, Australia and New Zealand against Japan, in which the tribunal prescribed precautionary measures outlawing experimental fishing programs for stocks of tuna based on a precautionary approach. Now at 4.24, where harm to global commons occurs outside the sovereign jurisdiction of a nation, such as in the high seas, or due to global climate, questions arise as to whether such harm is actionable, and if so, by whom. 4.30, environmental rights as human rights, and some commentary there. Just over the page, at 4.32, a principle of international law that all parties to a treaty conclude a more specialised treaty. In those circumstances, the provision of the later prevail over the former. The reason I just highlight that is that as a general principle of law, that where you have a general provision in conflict apparently with a specific provision, then the specific provision will override and bind the parties, irrespective of what's said in the general provision. That's the general rule. Now, the influence of international law in Australia at 4.43, Bates says, of course, that international law has no automatic application in Australia. To be effective, it must be translated into Australian law by domestic legislators. And there's very little federal environmental law that does not spring from international obligations. And on page 137, there's a table which shows the treaty-based sources of Commonwealth legislation. So you'll remember, of course, in earlier talks, where the Commonwealth is restricted in its ability to make environmental laws because there is no power in the Constitution, specifically, that entitles the Commonwealth to do so. So the Commonwealth, in enacting environmental law, such as the EPBCA, must rely on other factors which are set out in the Constitution, section 51, and one of those is well, the Commonwealth has power to deal with international treaties and international law. So that can then be used and morphed, if you like, into environmental law. Now at 4.45, not all international obligations find their way into domestic law. Climate change and management of greenhouse gases are a good example. At 4.47, a court or tribunal might be influenced by principles of international law and policy, even in the absence of any direct recognition and in the particular domestic law in front of it. The case referred to there is Leach against National Parks and Wildlife Services, where the Land and Environment Court, which is like our Planning and Environment Court in Queensland, that is in New South Wales, accepted the legitimacy of the precautionary principle as a means of decision making, even though the legislation in question neither referred to the principle nor required such an approach. And that's another example of how the precautionary principle, which is one of the aspects associated with sustainable development, is creeping into our current law system locally. All right, well that's a very brief overview of Chapter 4 of Bates. I hope I haven't gone too quickly. The idea of the overview is it provides you an opportunity to follow what I'm saying, not because what I've selected is necessarily the most important part, but it gives you a guide as to what I believe is the most important part of each chapter. So unless there's any questions, I'll stop the recording at this stage. Thank you.